Welcome to the next installment of the lectures for Data Use Privacy Law class. I'm Lisa Thomas, a partner and lead at the Privacy and Cybersecurity practice at Sheppard Mullen and an adjunct professor at Northwestern Law School. And today we're going to look at the differences between CCPA and GDPR. These are two laws that are of particular focus for companies right now because they are the two newest laws. There's other laws that are coming up. By the time you read this, there probably have been 15 or 20 new laws that have been passed. So remember when you're looking at these that these are not the only laws out there, and also that these laws change. They change all the time. All the laws change all the time. So as always, this is intended to be a framework for you as you go and you look at the text of the law itself, and is intended to supplement the reading assignments that you've had, including both the written assignments that I prepared, as well as the copies of the laws themselves. So let's remember that for all of the privacy laws that are out there, we're always going to be thinking about concepts of notice and the extent to which the law requires providing consumers or individuals with some sort of choice. And both CCPA and GDPR address these concepts, but then they add a lot more. They have a lot more specificity around how you give notice, how you give choice. And as we've seen, and as we will see, that's one of the benefits with a global law approach, is that there are a lot of details which companies can find helpful. But that can also be one of the risks, is it can be complicated to implement and understand all of those details. So let's think about what is different. So probably the biggest difference of CCPA and GDPR from many other privacy regimes is that it has this concept of giving consumers, giving individuals broad sets of rights. So the first thing that would happen is a consumer or an individual would ask to exercise one of their rights. One of the rights might be to opt out. For CCPA, that means opt out of selling. For GDPR, it's broader. It might be opting out of, you provided consent to marketing and you want to opt out of marketing consent. You might also have a right of understanding what information has been shared. What information did you share with me with third parties? There are rights under CCPA and GDPR to access, which means what information do you have about me? And finally, there are rights around, under both, there are rights around deletion. I want you're not using my information anymore. I want you to delete that information. Finally, CCPA has this concept of non-discrimination, which exists a little bit under GDPR, but not quite in the same format. And the idea here is that you can't discriminate against someone simply because they've exercised their rights under CCPA. So they ask to have their information deleted, and now you're going to retaliate against them. So the law specifically prohibits them. So when you think about CCPA, when you think about GDPR, one of the things that you will want to do is think through what parts of it are the same and what parts of it are different. And this slide gives you an understanding of how you would go about verifying whether someone is indeed the person who they say they are before, for example, you tell them everything you have, all the personal information that you have about them, or you delete the information that you have about them. So the process for verifying is a little bit different under both laws. And similarly, what information you're required to provide and how much information you're required to provide is a little bit different under both laws. And for those of you in this class, which is why you're watching this video, you will note that I am releasing this video after you did the assignment that compared these two laws, because this is a way for you to measure up against what you prepared and see the way I have divided it out. And you will notice for many of you that the way I've divided it out is not identical to what you did. That doesn't make what you did wrong. But often when we're putting these together, we're thinking about what questions specifically does the client have, or what are we trying to address? So the summaries that we have, or the compilations that we put together, are going to be a little bit different every time. And then finally, in comparisons, it's useful to compare the differences in requirements around deletion between CCPA and GDPR. One of the things that I do worry about for clients is that sometimes they think when we talk about giving access or deleting personal information, there's confusion about what is personal information. And CCPA's definition of personal information is probably the broadest that we've seen. It includes basically everything. I put in bold on this slide, it includes olfactory information, so it includes how you smell. So it's really absolutely everything. So something to keep in mind. Another issue that comes up in the context of both of these laws, but in particular CCPA, because it's a California law, is it really going to apply to all companies in the United States? And the answer is not necessarily yes. So it will apply, sorry about that, it will apply to businesses that are in California that have personal information, or they conduct business in California, have personal information. Almost every company is conducting business in California, but it will only apply if there's revenues of over $25 million or the company has information about more than 50,000 Californians or makes money from selling personal information. So most clients are going to reach this threshold if their revenues are high enough, because if they have information about Californians, that's the first part of this, so they're collecting personal information, then as long as they have high enough revenues, the law will apply. Which is why most of the companies that we work with are worried about it. There are some other sources of exemptions to CCPA that does not exist under GDPR, and is important and interesting to think about, because if we remember, GDPR lives in a world where there's just one global privacy regime, which is a universal. GDPR is a universal global approach privacy compliance law, whereas CCPA lives alongside of the laws that we've talked about before, which are industry specific or activity specific. So if you are, if you house data that is regulated under HIPAA or GLB, so that's industry specific, then to the extent that you are protecting that information, or it is regulated by GLB or HIPAA, then the CCPA wouldn't apply to that information. So finally, just a few thoughts about how you might think about, if you're working with a client, providing the rights or responding to the requests. You're going to figure out who the person is. There's a time limit around the amount of information under CCPA, not necessarily under GDPR. You have less time to respond under GDPR, 30 days, as opposed to 45 under GDPR. But with CCPA, we get one extension. For GDPR, we get two 30-day exemptions. And then again, the issue for CCPA, or sort of what makes the response shorter, is that our request is triggered by that 12 days. Both of them want the information to be provided, if it's an access request, to the individual in a machine readable format.